A motion in limine is a legal request made before trial to exclude or limit certain evidence or arguments during a trial. The phrase in limine means at the threshold, and it's a way for attorneys to address potential evidentiary issues before they arise at trial. April 9th, 2025, Motion 12, State's Motion, Demonstrative Evidence.
The demonstrative evidence.
Thank you, Your Honor. In our motion regarding demonstrative evidence, we were talking specifically about, for lack of a better phrase, a dollhouse, a not-to-scale construction, a 3D model of the residence itself. And as the court can see from the materials that have been submitted, the configuration of this house is unusual at best. Certainly we can use diagrams and floor plans, which we did at the grand jury. But it struck us as we were looking at this case that it would be particularly helpful for the trial jury to actually be able to see in a 3D sense how everything's laid out. What is on each floor, where the bedrooms are, how the first floors.
For it to be demonstrative evidence, what's important is whether it explains the testimony of somebody on the stand and helps the jury understand it in relation to the testimony. And the concept of a demonstrative exhibit is that it's actually part of their testimony.
Yes, Your Honor, that's exactly what I was getting at. What we contemplate is the witnesses being able to use this demonstrative evidence to demonstrate where they were, where the rooms of their roommates were, where the entries to the residence were, what they observed, and where everything was located. So it's not intended as a standalone exhibit that has significance. It's only a tool for the witnesses, not just the roommates, but the responding officers, the officers who investigated the crime scene, to point out to the jury where in this three-story structure certain things were that they observed. And so that is our intent on this. We initially contemplated offering a two-scale model. And the defense, I think rightfully so, said, okay, well, give us the background information and data that would be relied on. And we requested that, and for whatever reasons, we didn't get it quickly, but as we revisited it, we realized that to scale maybe is not what we want. We just want a demonstrative exhibit that witnesses can use, much the same as a sketch, or if they were to take a flip pad and try to draw things, to help illustrate their testimony to the jury. So that's where we ended up here. We look at the balancing test under 403 as far as relevance. We believe this will be helpful to witnesses and explain to the jury and to the jury in understanding witnesses' testimony. As far as prejudicial effect, the state doesn't perceive any significant prejudicial effect. Now, I realize that the expert witness for the defendant talks about jurors misinterpreting angles of view and stuff. Well, that would be true if we were dealing with a two-scale exhibit, and the defense is welcome to offer their 3D imaging or whatever it is that they want, if they want to have a two-scale presentation. That's not our intent, though. Our intent is just simply to have this as a tool to help witnesses explain their testimony and help the jury understand.
And I think you understand this, but so that, it's clear. If it allowed as a demonstrative exhibit, it's not an exhibit in the sense that it goes to the jury. When they deliberate, it will not go back with them.
Yes, we completely understand that. We intend this to be something in the courtroom that is physical, that the jury can look at and the witness can look at and point to things so the jurors have the most complete understanding of what their testimony is.
And I haven't seen it, so I don't know how visible it will be to, you've seen now where we're going to be, how visible it's going to be to the jury from where it would be presented. So I guess if I allow, we'll have to cross that bridge.
And that's understood. The last communication we had earlier this week, Your Honor, from the folks at the FBI is that it might be finished within the next 10 days. I'll be candid, I had proposed to the FBI, let us get this in front of the court and get a preliminary ruling from the court before you spend the effort to construct it, but they went ahead and started anyway. So that's neither here nor there. It is intended, as you can see from State's Exhibit 1 or S1 with the dimensions in there, it's a fairly significant size, 35 by 48 by 52 inches. So the idea of making it big enough so the jurors can see it's out in the floor in the well, and they can actually see how things are constructed and arranged. It can take apart floor by floor so they can see each floor individually and then how they are stacked back together. So that's the purpose, to assist witnesses in explaining their testimony and assist jurors in understanding the testimony.
April 9th, 2025, motion number 12, defense's response to demonstrative evidence.
Your Honor, we request that you exclude the state from using this dollhouse model. As is everything we're talking about here today, we're talking about Mr. Koberger's constitutional rights, and we're talking about the rules of evidence. In this case, though, Your Honor, this goes beyond that. This is something that came up in 2023, the fall of 2023. We were disclosed that a group was going to the house before it was torn down to construct a model. We promptly asked in discovery to receive information about this model so that we could start to understand it, so that we could work with our expert with it. And it wasn't until 2025 that we get more information about this. I don't think that calling it a demonstrative exhibit excuses what the state has done here. The state said they didn't have any of the materials, they didn't come forth with them. Their date to be done with discovery came and went. Their date for their expert disclosures in December came and went.
Demonstrative exhibits and trials are typically not brought to light in terms of being shown until oftentimes during trial itself. I mean, it's no different in some senses, as I'm hearing the argument, of sketching on a diagram on a pad.
It's completely different than sketching a diagram on the pad, Your Honor. This, if somebody's drawing something in open court, I can see them. Mr. Koberger's confrontation rights about how that's drawn exist right then and there if they're drawing something on the board. This is an exhibit that's constructed outside. It's done in preparation for court. There were experts that took the 3D imaging to make this. There were photographs that were taken to make this. There's a process to construct this and to take it from to scale, which might have made some sense because things would be there where they're supposed to be. And by things, I mean walls, I mean doorways, I mean angles of hallways, I mean lines of sight. Those things would be there where they were supposed to be if we were doing this to scale. But to not do that and call it a demonstrative exhibit so they don't have to tell us about it is really misleading to the jury. And there's a lot of danger for the jury to be completely confused by that. I don't think this change excuses what the state did to sit on this information and wait until the last minute when we don't have any ability to investigate it or to look at it.
You have access to the house, right?
No. What, to the old house? Yes, but not to what they're doing now.
But you had the ability to create your own models, to do your own measurements, to come to an understanding of the layout.
Absolutely, we did. What we don't have the ability to do now is to test the state's model before it gets in front of a jury, before different witnesses use the state's model to say, this is where I was and this is what I could see. If a doorway's just off, the line of sight is just off. That can be completely misleading to the jury. This is an unfair surprise to Mr. Koberger. To have this come in and have the jury look at this, it's not a PowerPoint. It's not a drawing on the board. This is going to be this big 3D model that's going to be pushed around the courtroom. It's going to draw the jurors' attention. They're going to put a lot of emphasis on it. a demonstrative exhibit that may or may not be accurate, that may have the walls and the lines in the right place or the wrong place, that won't have depictions of furniture or the way the house really existed that night. And the jury can place great weight on that. And it might not be actual. It could skew the testimony. It could skew the truth. And that's really important in this case.
Where cross-examination comes in?
Your Honor, how can I cross-examine a 3D model that's constructed outside of a way I know anything about?
Well, you had access to the house and you know what the house looked like and you have photographs.
I do have those things, but if there's a slight shift in this 3D model, it's going to be more difficult to depict that. And that's a lot of runs around to try to get our expert to take a look at this, to try to get our expert to pull the 3D picture that would show that this model's wrong, and to try to get the jury to want to listen to all of that, when the best and easiest thing for the court to do is just exclude it. This is not a model that will do anything but cause the jury to speculate. It could easily produce testimony that's not true. The jury might be relying on things, and likely will be relying on things that are not true. When you look at the case law that talks about demonstrative exhibits, you're looking at things like PowerPoints. You're looking at, that's in the Weigel case, whether or not the demonstrative exhibit should go back to the jury. When you're looking at the Masters case, it's an exact car seat. That was a civil case. It's an exact car seat, like was in the case at bar at that time. Here, this demonstrative exhibit that's going to be large may or may not be accurate. Conversely, I have the photographs, so does the state. I've been in the house, so is the state. There's 3D imaging that was taken by the state and by the defense. With all of the thousands of photographs and all of the people that have been through the house, there's no reason to take a chance on this exhibit that will be speculative and will confuse the jury. To allow this is allowing the state to ignore the discovery process. They're just slapping a new label on this model and saying it's not to scale, so we don't have to disclose anything to you. To allow them to rename this is a violation of Mr. Koberger's constitutional rights to due process and a fair trial. This should absolutely not be allowed. Mr. Koberger we have done everything we can to be apprised of what the state's going to do, and at the last minute to pull this out after we've asked in discovery for this and to label it a demonstrative exhibit, Your Honor, that just can't happen if Mr. Koberger is to have a fair trial and if his due process rights are to be adhered to. We strongly object and ask the court to order this excluded.
The 3D, or in the I don't know if it's LiDAR or what they use, the 3D information.
I'm sorry, Your Honor.
Do you have the laser information,
As of March 4th or 5th, I think that we did receive that. We sent that to our expert. He wrote a declaration in support of our objection to this, to let you know how long it would take him to do the work necessary to even measure this, and then he'd need an on-site visit for this. And if the court allows it, that's what we have to do. But the court should be well aware that when the state does these kinds of things, these things mean taking their time and throwing things out long after deadlines come. There's a ripple effect that happens. We have to work with our expert. The expert has to carve out time in his schedule. We have to take time to understand what's happened and figure out how to respond to it. We are very close to trial, and those deadlines are important for a reason. All of the stacking up of things like this at the last minute outside of the deadline set by the court and outside of the rules further prejudice Mr. Koberger and his ability to have effective assistance of counsel at trial.
April 9th, 2025. Motion number 12, State's rebuttal to demonstrative evidence.
Your Honor, what Ms. Taylor is talking about might be true and applicable if we were offering a scale model. We made the decision not to. She complains about the timing of the underlying FBI data. Well, that request from her for that information related to a proposal for a scale model. And we provided it anyway because she had requested it. But in our view, it has no bearing on whether the demonstrative exhibit is acceptable and appropriate. The allegations that we've tried to sit on this and bury this, that's just silly. That's not what happened. We provided the information we received. As soon as we received it, it was processed. I don't think that the defendant can point to anything to say otherwise than that. It's just simply a demonstrative 3D model to help the witnesses explain their testimony and help the jurors to understand the testimony. That's all we're asking for.
Thank you. I will give you a written decision on this soon, shortly, but there is a significant distinction between demonstrative trial exhibits or trial models, charts, things of that nature, and attempts to use things for evidentiary value in and of themselves. Though more complex, it's not particularly different than a drawing by a witness or something of that. It's not uncommon to get these very close to trial. Defense counsel has had access to the house, could have done its own diagramming if it had wanted to. It has now the information on the, I'm just going to call it the laser or LiDAR modeling, measurements, whatever that was done by the FBI. It's April. Trial is starts in August. I think there's plenty of time for the defense to respond to an item that is not actual evidence. It is simply part of testimony that will be forthcoming at trial, and will not go to the jury. Jury will not have it in its presence when it deliberates. I don't see, frankly, the concern with respect to the use of a model in a case like this. So I'm going to allow it. The state will make it available to the defense prior to the pretrial conference, and sooner if it doesn't sound like it's complete yet, but as soon as it's done, and certainly as quickly as possible. And like I say, it's not going to be allowed for evidentiary value. It will be a part of the testimony. Whoever testifies is going to have to testify that it helps explain their testimony and that it's consistent with their observations. That's subject to cross-examination by counsel. If there are problems with the model in terms of view lines and things of that nature that they were able to put together through their own visits, through their own studies, through their own opportunities, including through their experts if they want to.